All right, welcome back, everybody. We are here finally to have presentation that I had asked Damien to prepare several weeks ago now. And the kind of presentation he can do in his sleep. I think you just have to give him a number of how many minutes or breaths he needs to take in order to do it. But it was just about, so we just kind of rewinded a little bit to the beginning of this conversation about collective bargaining. And I just wanted him to give us an introductory, kind of a 101 on Vermont law and the process. We've heard some about it in testimony on S102 and on PR3. But happy to finally be able to grab some time with Damien to do this presentation. So Damien, welcome back.
Thank you. Happy to be here. For the record, I'm Damien Leonard from the Office of Legislative Counsel. So I'm going to do a PowerPoint presentation for you today. Bear with me. I'll try to go quickly, and then at the end we can stop for questions and kind of backtrack as we need to. So let me pull that up for you. Get started. All right. Great. All right. Really?
His daughter's got that down.
I don't know why there was animation at the beginning. So clearly this is going to be a bad presentation. Anyway, so I'm going to try to keep things fairly high level. We can go really deep in the weeds on this subject, but we're going to start with the federal laws because the federal laws really undergird what we can actually do at the state level. Then we're going to do a quick overview of just what Vermont actually governs, what we actually cover for collective bargaining. We're going to talk about the labor board. We're going to talk about who can collectively bargain, what you can collectively bargain about, and then a very high level of the bargaining process and dispute resolution. It's really important to note when we get to those last two that that is the ideal world. So that's the way the rules set things out in the ideal world. The reality is that oftentimes collective bargaining can be a lot messier than the ideal world, with lots of back and forth between the parties, and sometimes it can be very smooth. And so when we're talking about this process, you may be familiar with negotiations that have occurred in your district or that a family member has been part of on either the management or the union side, that either do or don't fit within these models. And that's just the important thing, is that these are the basic guidelines, but there are 1,000 different ways a negotiation can go once the bargaining unit forms, depending on how the parties work together and what it is that they're trying to negotiate over. So that's just something to keep in mind. Okay, so what are the federal laws? So the first to keep in mind is Railway Labor Act. This is not just railroads, but also airlines. So when you hear about flight attendants and pilots going out on strike, that's under the Railway Labor Act. The big one that we talk about much more often here is the National Labor Relations Act. This is most private sector employers and employees. It does not apply to agricultural laborers, domestic workers, or independent contractors. The first two are types of employees who are excluded. Independent contractors, you don't have an employer-employee relationship. And so that's why independent contractors are excluded. It also excludes state and local public sector workers. There is a separate federal collective bargaining law for federal employees. We're not going to touch on that today. But suffice to say, we can't govern collective bargaining for example, postal workers in Vermont. Okay, so in Vermont, our first law was the State Labor Relations Act, which is really a backstop for the National Labor Relations Act. At the time when it was enacted in 1967, so almost 60 years ago, business was different in Vermont. There was more of a state level, not interstate commerce, business scale that could occur here. So it was more conceivable that the State Labor Relations Act would actually be triggered because it applies to private sector workers who are not covered by the National Labor Relations Act, which means they can't be doing business in interstate commerce. Interstate commerce these days in Vermont, it's anything that deals with, that crosses state lines for the business. So if you're talking about working with tourists, you're in interstate commerce. If you're buying products that were made outside of Vermont, you're in interstate commerce. If you're selling products made outside of Vermont, you're in interstate commerce. So as you can imagine, really quickly, we've eliminated pretty much every private sector worker in Vermont because these days everything is crossing state lines, if not international lines.
Cannabis.
Cannabis is an exception because of the federal law. So federal law prohibits transporting cannabis across state lines. Federal law also prohibits possession and sale of cannabis, but we'll leave that aside for the moment. But that is one where that is intra-state commerce, not interstate commerce. So that could conceivably fall under the State Labor Relations Act if you have a cannabis company in Vermont with 5 or more employees. It would be really interesting for me to see if, for example, a cannabis retailer is arguably in interstate commerce because of the tourists who come here to buy cannabis. But it would be really interesting for me to see how that would go at the National Labor Relations Board if there was an organizing move because of the federal law implications. I don't know what the answer is, but certainly with cannabis producers, you could see collective bargaining there, except for the limitation on agricultural workers, which is in our statute as well. So it would have to be someone who is processing cannabis into, for example, edibles or something like that.
Cannabis is not an agricultural crop
Okay, let's,
in law.
Without going down there, we don't define agricultural. And to me, you're growing something. I think if I was the employer, I would make a strong argument that that was agricultural work because we're growing the crop that produces the product in the same way that tobacco is an agricultural crop. So
it's in Bartley and then Lamont could, I won't limit you, I'm sorry.
This will be super quick because this is absolutely the Damien show. I think I've said it before and I'll continue to say it. Cannabis will always be a really, 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 really bad example for our purposes and what we do in this committee. It's just a beast in and of itself.
I don't disagree, but but we have it. Yeah.
Okay, and so I know this is gonna be complicated and I'm gonna try to make it not complicated, but it's similar to that question, but not really because it's about collective bargaining. And so in the.
Sorry.
I know, but I'm just thinking of the folks who harvest, because I know that they have people who are seasonal who come in just to harvest and trim and then they go, but they're groups of people of 5 or more. So, but because are they temporary? Would they have rights or
they're
no?
agricultural workers,
So
they don't have rights.
They don't have rights
or federal
because
law.
it's agricultural because they're working on the farm. Okay, thank you. That was
Unless
quick. Look at that.
unless they were contracted through federal programs, most marijuana can't apply for.
Right, but they still don't have collective bargaining rights. So
They have some rights.
yeah, agricultural workers may have rights under a variety of state and federal laws for employment protections, particularly if you're here under a federal visa program.
Right.
But those rights are limited. And then no matter what, you don't get collective bargaining rights.
Yeah.
So under both state and federal law.
unrelated to cannabis. On the first slide, talked about railway and airline as separate from the National Labor Relations Act.
Yeah, it's a
Are
separate.
those because they're critical national infrastructure pieces, or?
You know, that is a beast of history. So if we go back here, so Railway Labor Relations Act or Railway Labor Act was enacted 9 years before the National Labor Relations Act. And really, if you want to talk about this, so what I cut out of this presentation, maybe I should have left it in because it would have been fun for everyone, was the history of collective bargaining in the US and in Vermont. But in the 1800s, there were efforts by railway workers and factory workers to unionize. They were often put down by the National Guard or other paramilitary organizations in some cases, like the Pinkertons. And so at that point, I mean, there really was, it wasn't just bargaining at the table. There was real sort of violence on both sides of the movement between labor and management, where management would bring in established military force, labor would walk out on strike. There was there was a lot of violence in the movement at that time. And I don't know the full history of the Railway Labor Act, but my guess is because of its role as national infrastructure critical to commerce, that was why you saw unions first authorized there, was to avoid some of these breakdowns. And then the National Labor Relations Act, that was part of the New Deal. So you'll notice Railway Labor Act is before FDR was elected. National Labor Relations Act is during the FDR administration. So that's the New Deal, where there was a whole host of things that came out of the Depression and FDR's reimagining of labor laws in the US and the legal landscape at the time, where the Supreme Court, the switch in time that saved 9, for those of you who like that, where FDR was going to pack the court, and the court suddenly changed its view on labor legislation, and FDR backed away from court packing because they allowed his first New Deal law to pass. The Railway Labor Act, though, was under the Hoover administration.
Or Coolidge.
Was it Coolidge? Could have been. But either way, it was pre-FDR. And pre-Depression. So it was a different era. But that was really the first one. And then they added airlines in the 30s as part of the New Deal. So, but that's worth just noting there. They're broken out, and that's all early 20th century American history there. That gets into that.
Just real quick, it's a yes or no question, okay? But you brought it up, and so it piqued my interest. Okay, you used the terms put down and violence, and it was the 1800s. So does that mean unalived? I'm confused. Like, what was the level of the conflict with trying to create the unions and the railroad, like the railroad workers? Is that like?
So the level of conflict was, there were in some instances, not every instance, there were in some instances violence and death.
Yep.
So this was.
I'm like, that was it. I was like, wait,
There
is
was-
that what we're talking about?
There was real armed conflict. There were a number of strikes in Vermont that were significant, that resulted in arrests or armed clashes between workers and folks hired by management. So there were instances, not across the board, but there were instances where there was real violence, and that's one of the things to keep in mind with these laws. Is these laws basically set out the rules for the two sides to come together in a way that doesn't involve violence to settle differences over how things are going to function in the workplace. And so that is one of the really important things to remember about the collective bargaining laws, is they really are a form of dispute resolution that was set up between workers and management for these instances that came out of industrialization, where you got into bigger workplaces where suddenly there were a lot of workers, and you had big separation in terms of monetary power and so forth between some of these parties, especially in the Gilded Age of the US or in the early 20th century. And this was set up to sort of be a way to solve that in some cases. That's, not every workplace fits within that paradigm, but that was part of the problem that they were addressing when they enacted some of these laws, is that they had work stoppages that had caused huge disruptions. And how do we figure this out so we can get the parties to talk and resolve their differences and keep the economy moving forward?
And one last historical tidbit, the exemptions to the NLRA match the exemptions to the federal minimum wage.
This was part of the compromise in the New Deal. There were certain things. So if you go back to that history, and there were a variety of things going on at that time. There was a child labor constitutional amendment, which, for the record, Vermont voted against. So our state was one of the states that voted against child labor protections. But one of the big opposition points for some of this labor regulation was agricultural states, farming states, did not want the labor regulations because it disrupted the way business was done on the farm. It also drove up costs for farmers at a time when farmers were struggling during the Depression. Their domestic workers was another one that has a lot of history, particularly with some of the southern states in Congress. Their representatives pushed for some of these exemptions. So there were, and originally these acts applied to far less workers. And then over time, for example, the Fair Labor Standards Act was expanded to pick up a lot of the original exemptions. And then with the National Labor Relations Act, it's been modified several times. And then you see states starting to add their own collective bargaining protections later on. But that's one of the things to keep in mind here. Really, to understand this, you're probably better off reading a history book of sort of like the politics of the New Deal. And that'll give you a sense of where the country was at that time. And a lot of this is an outgrowth of that, with tweaks over time since then to keep truing it up to the national economy and the national politics. Because the reality is that these are laws enacted by politicians. So the rights have ebbed and flowed for both sides over time, depending on who's in power and who's driving the conversation in Congress or in the State House.
To bring us to this slide, it took
Yeah.
32 years after the national act in order for Vermont to feel like they needed to address their own needs individually
Right.
through this act.
So we have State Labor Relations Act in 67. It's modeled on the NLRA, and it covers private employers with 5 or more employees who are not subject to the NLRA. 2 years later, we get the State Employees Labor Relations Act. This covers most state employees. It also covers UVM, the state colleges, the Defender General, state's attorneys, and state paid deputy sheriffs. The last 2 there have been added in the last 10 years. So those are 2 more recent changes. It also created our Labor Relations Board. It also creates the whistleblower protections for state employees. And then in 1969, we also added labor relations for teachers and administrators. act here. So it covers all publicly funded schools in Vermont, which includes independent schools that receive support from public funds. So this really does cover pretty much every K through 12 school in Vermont. And then in 73, we added municipal employees. So this is any municipal employer that employs 5 or more employees. So there are still some smaller municipalities that are not subject to this. It also provides the unfair labor practice protections for teachers. So that's one of the interesting things to see here. We added teachers' collective bargaining. The unfair labor practices protections came 4 years later in a different act. And unfair labor practices are really acts by one side or the other that are coercive or are meant as a way to sort of get around the rules. No side in collective bargaining has a monopoly on unfair labor practices. If you look at the case history in the state, both unions and management have been accused of it, and the board has found unfair labor practices. Unlike other things that are prohibited by law, there isn't really a penalty for unfair labor practices. What you get is an order from the labor board to basically stop doing that. And they may, in some cases, order remedies like your unfair labor practice prevented bargaining from occurring, so you have to bargain with a union there because you disrupted the election or something like that. In 1998, judiciary employees got the right to collectively bargain. That covers all the employees of the Vermont judiciary. It is based on the State Employees Labor Relations Act and essentially mirrors it for all practical purposes. And then in 2013 and 2014, right? Oh,
So based on what you just said, though, what's important to note is that all of the acts do not mirror each other.
no,
Each one has its own nooks and crannies of differences. And so sometimes we'll hear legislation or we'll hear from some of the particular unions to say, well, we want this piece that's in this other act to be put into the act that supervises us. So it's not the same language 5 or 6 times.
yeah.
Each one was negotiated through this process.
Yeah, one of the probably the most unique of the public sector acts in Vermont is the Teachers Act. The judiciary and state employees are extremely close to each other in terms of the details. Municipal is a little different, particularly because it deals with public safety employees, and then teachers have their own sort of unique act. One of the really important differences in all these acts is how do you resolve impasse when you get to a collective bargaining impasse? Because in some cases you have a right to strike, in most public employee cases you do not. So police, fire, and state employees cannot go out on strike because we're considered essential employees. So you can't, I mean, imagine if the fire department was out on strike and you had a fire. There's no one there to help. So they're not allowed to go out on strike. So they're given other ways to resolve, in that case, by arbitration. If they get to an endpoint, the parties cannot overcome their impasse. They go to arbitration and an arbitrator decides what the contract's going to be.
If you have a right to strike, the management has a right to impose.
Right, so the Teachers Act has an explicit right to strike after a cooling off period, and management, we call them the hammers, and I'll get to that later. They've been referred to as the 2 hammers at the end that you can, imagine basically it's the hammer to drive your point home. So management can impose a contract on the teachers. The teachers can walk out on strike. That happened in South Burlington, or was it Burlington? South Burlington. My first year here in the legislature, that happened in South Burlington. And the legislature, the House, not the Senate, it didn't make it out of the House. The House came very close to taking away the right to strike. After that happened, it made it to a vote on the floor in the House. It was a 2-day floor fight in the House that took the better part of 2 days, and eventually the bill just died completely after being rewritten twice on the floor in 2 days, literally cutting everything out, dropping in something new, and then doing it all over again. So it was one of the more dramatic floor fights I've ever witnessed here. But that was something that happened. And these things, I mean, as that shows, get extremely emotional, extremely charged, especially when you're talking about things like public education or public services. There's a lot of emotion and concern that comes into this building because of what you do on a daily basis in a way that's different from private sector collective bargaining, where, you know, the plant workers might be striking, but it doesn't affect your kid's ability to go to school or something like that.
Final point on the Muni Labor Relations Act that now also includes some school employees as well.
It does. So we'll talk about that actually in a future slide, who's actually covered, and that's where things get even a little more complicated. The last two public sector acts in Vermont, these are not true public sector acts. These are what we call quasi-public employees. So they are employees who are employed by a private employer, but their salary is paid with public funds. So the first is independent direct support providers. This is your Choices for Care program, plus attendance services, children's personal care services, and developmental disability services. These are essentially caretakers who provide care to an individual, but the funding comes through the state, through, I think, Medicare and other federal funds. So they can negotiate with the fund over their hourly wages and reimbursement, but they can't negotiate over conditions of employment because that's governed on an individual basis.
So the people who are hiring the support providers are the person with the developmental disability.
That's right.
Through a third party. Usually there's a management. But the idea here is that that individual receives X amount of dollars a week.
Yep.
And can basically, their family can decide, well, we want 10 hours at $15 an hour, or we want 15 hours at $10 an hour. And we created minimums. Anyway, that was basically the minimum piece. Mary?
Thank you. Is it Medicare or Medicaid?
Medicaid.
Oh, Medicaid. I'm sorry. Yeah, that is a misspeak on my part. Thank you for clarifying. But yeah, that is, I think a lot of the funding for that comes from Medicaid. But yeah, oftentimes these are family members of the individual who's receiving the care. And so it's set up to allow these individuals to receive care in the home rather than being institutionalized.
So not only pay, but also training.
I think so. I think there is some professional development that they negotiate over with the state.
Very limited. It's very.
Yeah, I don't know a great deal about these programs, but this was set up. And a number of other states have this. The other one is, and that one there is a statewide union, I believe, or at least they did unionize, and I assume the union is still in place. The early care and education providers, these are licensed and registered child care home providers, and then exempt child care home providers. They get reimbursement from the state. They are allowed to bargain with the state over a limited list of subjects. However, to the best of my knowledge, this group has not unionized. There was a drive, and the union lost the election. But this is another group where it's dispersed providers who are getting state funding, and this was they have the option of forming a union to negotiate with the state over funding at some point in the future.
An example of, we created a tool for that.
Right. And it, at this point, hasn't been utilized. Okay, that brings us to the labor board. So as I mentioned earlier, it's created under CELRA. It has 6 part-time members. They sit in 3-person panels. Of the members, 2 are management side, 2 are labor side, and 2 are so-called neutrals. The work experience of the neutrals has historically created controversy in this building, because it's often hard to find someone who is truly neutral. And so a few years ago, there was a great deal of controversy created when someone who had experience working for a management side firm was appointed to the board. But there is an appointment process that's supposed to take into account the opinions from both management and labor in putting together candidates for appointment to the board. They make bargaining unit determinations. So an example of this is under State Employees Labor Relations Act. The sworn law enforcement officers in the non-management bargaining unit petitioned to form their own bargaining unit about 10 or 15 years ago. It went all the way to the board eventually. The board said, you don't belong in a separate bargaining unit. It would cause too much fracturing of the bargaining units in the state if we started splitting out everyone who has slightly unique interests. And then that would defeat the purpose of collective bargaining. So that's one of the things they do. The other thing they've done in the past is with teachers. At one point, so teacher, for purposes of the Teachers Act, includes anyone who's licensed to work in a public school. So that includes, for example, your school nurse. And this was one of the main cases there was who is a teacher under the act. Union claimed the nurse was part of their bargaining unit. The school said no. The board ended up ruling with the union there to say the teacher or the nurse needs a license to work in the school.
Oh.
Statute says licensed employable by a public school.
Huh.
And so the nurse was included in the teachers union and in that bargaining unit. They conduct the representative elections. So once there's a petition to form a union, the board conducts the election. They hear the unfair labor practice and grievance cases. So if there's an allegation that one side or the other is engaged in unfair labor practices, they'll make a determination of whether that's occurred. Also, if there's a grievance that one side or the other has violated the contract, they will be the final arbiter of the grievance if it can't be resolved before then. They are also an option for the final step of resolving a bargaining impasse over a contract under the State Employees and Judiciary Employees Labor Relations Act. The other option is going to a third-party arbitrator, and that was put in at the same time as that controversy over the appointment of the neutral member to the board. That was requested as an addition, I think, the following biennium, to basically give either party an out from the labor board if they feel that the labor board can't be impartial. So I think it's been utilized at least once. You'd have to ask the state and the unions how they feel about it.
So it's any of the, any management versus labor?
This is when you're bargaining a contract. So when you're negotiating, say, the contract for the non-management state employees, if they get to the end of the contract and they can't reach agreement, we're going to talk about how you resolve impasse. But if they get through the entire impasse resolution process and they still haven't gotten to an agreement, they have 2 options. One is to submit their last best offer to the state labor board. The other is to submit their last best offer to an arbitrator. The big difference is the labor board is a 3-person panel, and it's taxpayer funded. The arbitrator is an individual, and the arbitrator is paid for out of the pocket of the union and the state.
So this is only for Zelra and Jelra.
Yep.
Okay.
And last best offer cannot be edited
That's right.
by the adjudicator.
That's right. The current law is you have to pick it in its entirety. There are different models for this. We'll talk about that a bit when we get to that point. But the current model is that you basically put your last best offer on the table. And the board or the arbitrator has to pick one offer or the other. They can't pick part A from one and part B from the other and mix and match. That gives you an incentive to be as reasonable as possible on everything. And this is, I can't remember if it was the state or the VSEA that got bitten by this in the past, but there was one contract that went to the labor board where one of the parties included something that had never been discussed in negotiations. And because that one provision, the board viewed it as so unreasonable to put out something that had never been brought up, they basically voted in favor of the other best offer, which they also said, we don't think this is very reasonable, but it's the less unreasonable of the two. And it was because of that party threw in something that had just not been even discussed between the parties. And so they found that sort of last minute change to be so unreasonable that they wouldn't even consider it. What's that?
Like a floor amendment for us.
Yes, I mean, it was, you could hear the exasperation in the opinion.
Yeah.
You know, they didn't think either party was playing nice, but that really put them over the edge.
Dennis?
So,
I'm just trying to think, I'm not real familiar with the public sector, but is there like, does it go to fact finding?
yep, we'll talk about that in a second.
Okay, all right.
Yeah. So,
But the last point on that to me is simply, sorry, it's simply, this is a piece of frustration for both sides. Because the last best offer is, well, that's an extreme, the example, there's just times when reasonable people might have been able to negotiate knowing what the last best offers were.
mhm.
The system does not.
Yeah, and there's a lot of opportunity in the dispute resolution process for heartburn. So I'm going to speed up because I realize you guys are getting late in the day. So State Employees Labor Relations Act, we talked about who it provides bargaining rights to. It's state employees, state colleges and UVM, state's attorneys, and state paid deputy sheriffs. It includes permanent part-time employees and individuals who are out of work because of a labor dispute or an unfair labor practice. So you can't get fired in retaliation for your union activity and then be told that you're not an employee covered by the act if it's a violation of the Labor Act. It does not provide collective bargaining rights to employees that are not part of the classified service, except for state troopers, defenders general employees, deputy state's attorneys, and other state's attorney employees, and the full-time deputy sheriffs. So in general, when you hear exempt from the classified service, it also means exempt from collective bargaining rights. Employees of the Department of Human Resources, classified or not, can't bargain because they have a conflict of interest because they also administer the agreement on behalf of the state. Managerial employees are in management, so you can't bargain with yourself. Legislative employees and the lieutenant governor's one employee, although the statute uses the plural. I guess it's optimistic that at some point our lieutenant governor might have 2 or 3 staff. So we can't bargain. And then employees in the Department of Finance and Management who work on the contract also can't do it. And then confidential employees and private secretaries. So these are people who work directly for the appointed official or the governor providing legal or policy advice. And then private secretaries who know all of the secrets of the office. So that's who can bargain under state employees. Under judiciary employees, it's very similar. I'll get to that in a second. Teachers and administrators. So as I mentioned before, teacher is any person licensed employable as a teacher. That definition of teacher has been stretched to include anyone else who's licensed to work in a school. And then administrators, anyone who's licensed as an administrator for a school, not including, actually anyone who's licensed as an administrator. So what you'll see often is, for example, in a larger school district, you might have a union representing principals and assistant principals, but very unlikely that the superintendent is going to be part of the union. But it's possible. This is far less common than the teachers. Teachers are your main unions underneath the LRTA. Municipal Labor Relations Act. So this is any employee of a municipal employer, including a professional employee. This includes unlicensed school staff, custodial staff, ground staff, facilities staff, and anyone else who doesn't need a license to work in the school but works in the school is considered a municipal employee. This does not provide bargaining rights to your select board and other elected officials or your town manager. It doesn't provide rights to supervisors, probationary employees, confidential employees to your town attorney, certified employees of school districts. So this, except in relation to unfair labor practices, this basically means all your licensed school employees do their unfair labor practices work through the Municipal Act. Judiciary employees, any individual employed on a permanent or limited status basis by the judiciary, including permanent part-time, does not provide collective bargaining rights, though, to the court administrator, managers, law clerks, attorneys, administrative assistants, to the judge, justice, or court administrator, temporary, seasonal, or on-call employees, including interns, probationary employees, heads of departments and divisions, attorneys for the Supreme Court, or any the court administrator or boards or commissions, and employees paid by the state appointed employees who are paid by the state and appointed part-time as a county clerk. That's a nice typo. And other employees in a position determined to be sufficiently inconsistent with the spirit and intent of GELRA to warrant exclusion. And that is a judgment call for the labor board. Basically, just like the state, if you're involved in administering the contract or you're closely tied to the management in the judiciary or you work directly for a judge, you don't get the collective bargaining rights. If you're general court staff, you do. So when I was a law clerk in the court, I couldn't collectively bargain, but the staff in the front of the courthouse who took the complaints and managed the calendar, they were all part of the union. All right, I'm going to speed through the subjects for bargaining because it's very repetitive. Wages, terms and conditions of employment, and hours. So the CELRA is the most extensive list and it goes into a lot of detail, but it basically comes down to working conditions, wages, hours, and other terms and conditions of employment. And even though these are stated differently, the reality is they're all pretty much the same. We've just said it more briefly in the later acts. So one of the important things here is mutually anything that they agree to bargain over that's not in conflict with statute. You cannot bargain around statute. So, and that's really important. So if you set something in statute, the union and the employer can't bargain around it. One thing for teachers that's unique is healthcare benefits and coverage is bargained at a statewide level. And we set that up, I think, about 8 years ago now. So I'm gonna skip over these guys because we're running short on time and it is repetitive. So now we get to the bargaining process. So duty to bargain, that is the key thing for all of this is the whole point of these acts is once you have a union in place, management has a duty to bargain with the union and they have a duty to bargain in good faith. And so that's the important piece. That's why the acts were formed. The two sides must participate actively in a manner that indicates an intention to find a basis for agreement. But it does not require either side to make a concession. Taking a firm position that you cannot budge from is not bargaining in bad faith. Provided that you're not just taking it for the intent of just frustrating bargaining and getting to arbitration or something like that. This is, as you can imagine, a very subjective call, and this is something the labor board is called on to decide all the time. When these disputes go up there, it often includes an argument that they were bargaining in bad faith. So it can include efforts to shortcut the process, get us to impasse as fast as possible so we can hire an arbitrator because we think we have a good case in arbitration. Attempts to undermine the authority of the bargaining representative. So going around the representative to talk to the union or to talk to the school board or something like that. Attempts to avoid settlement, making ridiculous offers so that the other side can't accept. Violation of ground rules. So oftentimes at the beginning of bargaining, the two sides will agree on ground rules. One of the most common ones is one side releases something that they agreed to keep confidential to the public to try to get the court of public opinion to come down on one side or the other. When do we start? Every act has different language around this. So SELRA is within 1 year before the act expires. So currently, I don't know if they've reached an agreement, but negotiations are ongoing for the next bargaining agreement for the state employees. Teachers is 120 days prior to the earliest school district annual meeting. So that gives you basically 4 months before the annual meeting, at least, if not earlier. Judiciary employment, anytime within the year preceding the expiration, or before that, if both parties consent. So those are the basic guidelines. And then within that, you can get all sorts of variation. And importantly, there's no deadline to finish really, but there are some functional deadlines. With the state employees and the judiciary employees, we have appropriations. And with teachers, oftentimes the school board has to come up with a budget that they then have to warn and get to the voters. And so that's what often happens with public sectors. You've got a budgetary fiscal year deadline. There have been cases though where it's gone past the deadline. And so that will crop up from time to time. But generally things are set so you get to dispute resolution in time to meet the deadline. And that brings us to dispute resolution. Every act has a slightly different process for resolving disputes. The first step is usually mediation. So you sit down with a mediator at one or more meetings, and the mediator tries to get the sides to figure out common ground. The second step is fact-finding. Fact-finding is where the parties make their case to an independent, either an independent individual or a panel of 3, where each side appoints one member of the panel, and then those 2 members appoint the third member. And in fact-finding, what happens is basically they give a non-binding decision that says, we think this is where you should reach agreement. And they can pick and choose from the 2 sides or pick something in the middle. The third one is arbitration or a hearing before the labor board. So the labor board comes into play for state employees and judiciary employees. For municipal and teachers, it's an arbitrator, and there has to be an agreement to go to arbitration, except when strikes aren't permitted, and then arbitration is mandatory. And then the final two things, they're called the hammers. I just like that term. It appears in some of the decisions. But it's contract imposition, which is what it sounds like. Management says, we can't reach agreement. Here's your contract. These are the terms. The counteract to that is to walk out on strike. And this is usually required only permitted after a cooling off period. So the parties are given, under the Teachers Act, it's 30 days after fact finding to reach agreement before either side can do this.
And also in arbitration, how that works is that there's a list of arbitrators, and then both sides have to agree with the arbitrator. It's gonna, who the arbitrator.
Yeah, so ideally the sides mutually agree. There's usually an out where if they can't mutually agree in a certain period of time, they ask an independent third party, usually the American Arbitration Association, to appoint that arbitrator. And then they would appoint from a list of arbitrators. One of the big challenges for this is we do not have a lot of alternative dispute resolution folks in Vermont. So oftentimes you're booking these people when you start negotiations just in case. And oftentimes they're not from Vermont. So they may not understand your local budgetary needs or how the local community works. They may just be the only person who is available for the New England, New York area at the time you needed them. So that can be a real challenge with these issues here. All four of the Public Labor Relations Act specify mediation as the first step. It's voluntary. Under SELRA and GELRA, the Labor Board appoints the mediator. Under the MELRA, the Commissioner of Labor appoints the mediator. And under the Labor Relations Teachers Act, parties have to agree on the mediator, and if they can't, they go to the American Arbitration Association. For fact-finding, I talked about the process. It does include hearings. There are different timelines. I'm going to breeze past those a bit again because it's getting late in the day for you. But generally, it's within about 2 weeks after going to mediation. Then you would agree on a fact finder. Just like arbitrators and mediators, oftentimes you book this fact finder ahead of time, so you've got your schedule mapped out if you can reach agreement. So under SELRA, the Labor Board would appoint a fact finder that's mutually agreed upon by the parties. And then if the parties can't agree, the Labor Board appoints the mediator from their own list. Under teachers, the Teachers Act, each party picks a member, and then those two members pick the third member. Under MELRA, the Commissioner of Labor appoints the fact finder. And then the fact finder, I should mention with all of these with fact finding, it's usually about a 30-day period for the fact finder to issue a decision. It varies a little bit from act to act. And then the parties have a cooling off period after the decision before it's made public. So that's the other thing. There's often a calculus here where sometimes that decision makes your position look pretty bad. Because the fact finder may say, this is where we think the reasonable basis is, and they're kind of the neutral third party. So if you're way off that on one side, you have an incentive to try to negotiate closer to that, because when it gets to the public, it may look like you're being unreasonable. And then that can put a lot of pressure on you to settle. And under GELRA, again, it's the Labor Board that appoints the neutral third party. After that, under Selra and Jelra, if you can't resolve your dispute within 20 days after the fact finder's report, you must submit your last best offer on every issue that's still in dispute to the labor board. So you might have resolved 20 of 25 issues. Those 5 remaining issues, you submit your last best offer. The offers become public only after they've both been submitted. So you don't know ahead of time what the other party has sent in. And then the labor board has 30 days to hold at least one hearing and choose one of the best offers in its entirety without any amendments. And this is where that gamesmanship about trying to be reasonable, but also represent your side comes in, because you don't want the labor board to think you're way off base, but you also probably don't want to concede too much from where you were at in your bargaining position. So those are the only 2 instances where you go to the labor board. The rest, it's arbitration. So under teachers, you can proceed to binding arbitration on 1 or more issues at any time after you reach impasse. You have to mutually agree on an arbitrator, or you can request the arbitration association appoint one. And then teachers have a unique option here where you can either agree to do the all or nothing last best offer in its entirety, or go a la carte, and the arbitrator can pick on each issue and dispute which side they think is more reasonable. So that's an interesting option, but the parties have to agree. And then strikes are prohibited after you agree to arbitration. So if you agree to go to arbitration, that's it. No strikes, no contract imposition. Under MELRA, you can adopt an arbitration procedure in the municipality. So some municipalities, like I think, don't quote me on this, I think Montpelier has adopted arbitration for its public employees, but this is up to the voters in the municipality. Or the parties can mutually agree on a case-by-case basis to go to arbitration. If your municipality has adopted arbitration, you can agree to skip fact-finding, which can save you money in the long run and get you right to arbitration. So the arbitration panel is formed if the parties can't resolve a dispute within 20 days after the fact-finder's report becomes public, assuming you haven't skipped fact-finding. And this is, again, that 3-member panel. Each party picks one and they pick the 3rd member. And if they can't agree, the Superior Court for that county picks the 3rd member of the panel.
Can you back up just a little bit? I'm sorry.
Mhm.
So the dispute resolution process that you just laid out felt like it was A, and if not A, B, and if not B, C, and so on and so on.
It's
But
really
you just said that arbitration can
and then
be,
B and then C. So you start with mediation in every case.
but you just said that you could skip mediation. You just said that. That's what's confusing.
I said you can skip fact finding.
Okay, you go to mediation.
So under the Municipal Act, you go to mediation. If your municipality has adopted by ordinance that it will go to arbitration anytime there's an impasse
Okay,
that remains unresolved, you can skip fact finding,
okay,
but not mediation. So
Okay.
mediation is step 1. Basically, it's like, ideally, we can get a voluntary agreement. And if we can't, we're going to have an arbitrator settle the dispute. So that's the way to think about it. First you bargain, then you mediate, and then you get to arbitration, and maybe in the middle, most likely you have fact finding, but not always.
I mean, fact finding is so expensive. Why would you even, if you had the chance to just go straight to arbitration, and mediation hasn't worked, why would you choose fact finding?
I don't know.
Arbitration, an arbitrator gets between $35,000 to $4,000 a day.
Yeah, I mean,
And so, and they could be 2 or 3 days. And with mediation, that's free,
Yeah, right. So you do mediation first, but then fact
Well-
finding can be like
mediators
$1,000.
can cost as much as $300 an hour.
Yeah.
To be fair, if you're hiring a private sector mediator, like
Oh, yes, you're right. Yes.
Yeah.
Yeah, private.
but it's each step costs more. The question that you're really gonna get is, do we think we can voluntarily reach an agreement after fact finding? Or if we're so far apart that we didn't reach the agreement in mediation, should we just go to arbitration and save ourselves possibly as much as, $5,000 to $15,000, depending on how complicated the case is and how long it takes the fact finder to resolve it, hold the hearing and everything else. Because at the end of the day, the parties are splitting these costs. And so for the municipality, this is money off the bottom line that could be spent on other things like fixing potholes. And for the union, this is money out of your members' dues, which is either going to cause you to have to raise your members' dues, or you're going to have less money to spend on representing them in grievances, contract negotiations, et cetera. So in both cases, your bottom line is getting hurt the longer you remain unresolved on an agreement. The question is, are you so far apart on what you're negotiating for that it's worth it? Or does it make sense to go straight to the arbitration? So you may say, we think we can get a decision, reach a mutual agreement off of fact finding because we're so close. And we bet that once public, so for example, if you think your case is going to make a lot of sense to the voting public in that municipality, you may say, let's go to fact finding. If they don't agree with us during that grace period before the report becomes public, let's hold out. Because once the voters see how reasonable we've been and how unreasonable they're being, regardless of whether you're the municipality or the union, the voters are going to come down on our side and say, sign the agreement. Don't pay $15,000 to an arbitrator.
On the other hand,
But
you know that there's one sticking point. Going straight to an arbitrator is actually,
and that's exactly it. It may be, we're never going to agree on this one point. Let's send it to the arbitrator. And that, who cares public opinion? We're never going to get an agreement. Let's go straight to the arbitrator. And that gives you the option there where you've adopted that. And the arbitration gives you basically the ability to avoid, it gives you the ability to avoid potentially the messy public finish to the collective bargaining process. The downside is the arbitrator may pick the side that you don't like. So each side has to be comfortable with that. You may get a decision you hate.
so just to clarify, every step of the bargaining, I have experience in teacher contract negotiations, but not the other areas. And I know that those are held in, basically executive session until you get to fact finding.
Right.
But then it goes back to the arbitration is private again, right? Or is
It is, but the contract's public.
Right.
And the key thing too with the arbitration is not so much the publicity. It's that arbitrator, you may get in there and that arbitrator may just totally disagree with your position.
Or they may be awful at their job.
And it's,
Yeah.
And as Damien started off with, what's the difference between this description and real life is often, it can match up, but it's often, especially in contract negotiations, can just deviate into emotional distress, which then causes, this is what we saw in a lot of school negotiations 10, 15 years ago. There was a lot of,
Yeah.
it can get really ugly.
Yeah.
And that prevents you from making what you were just trying to describe as a reasonable decision.
Mhm.
I want to finish at 4:15.
Okay. We'll get there.
I think everybody wants to finish
Yes.
at 4:00.
Yeah.
I agree.
Not me,
So-
I'm enjoying it. Keep going.
All right. So under Selra and Jelra, arbitration is an alternative to going to the labor board. Same thing as the labor board, though, essentially. It's really, you're just picking, are we going to be heard by one arbitrator or a panel of 3 from the labor board? But it's the same rules, last best offer. The arbitrator is mutually agreed on by the parties or selected by the arbitration association. The offers only become public after they're submitted to the arbitrator. And the arbitrator has to hold one hearing within 30 days and choose one last best offer in its entirety. That brings us to the hammers. So contract imposition is permitted under the Labor Relations for Teachers and Administrators Act after the parties have completed mediation and fact-finding and have not agreed to go to arbitration, followed and have gone through a 30-day cooling off period. So that's and then the other piece is strikes under the Teachers and Administrators Act. Again, mediation and fact-finding, followed by the 30-day cooling off period, not agreed to go to arbitration. Under MELRA, it's permitted after a 30-day cooling off period, provided the parties have not agreed to binding arbitration. And importantly, and this is where police and firefighter are prohibited from striking, the strike will not endanger the health, safety, or welfare of the public. So you cannot have all of your police, firefighter, or ambulance workers walk off the job.
I just have a quick question. It's a yes, no question.
Okay.
After the 30-day cooling off period, after everybody's cooled off,
Theoretically. Yes.
can they decide then, instead of pulling out the hammers, that they really do want to go back to mediation?
Yeah, or they could decide to go to arbitration at any point in there.
Okay.
These are kind of the steps. I don't think there's anything that prohibits the parties after fact finding from deciding they want to sit down with a mediator one more time now that they have the fact finder's report in their hands, or from just settling at that point. But the process sets out these steps. And these final things, they're called the hammers, and I like the term because it's dramatic. You know, and it's just what they've been referred to as in some decisions. And so I just grabbed onto it because it is a very dramatic finish. But it is also sort of your like point of no return option. We don't feel like we have any other option but to either impose a contract on you that we know you don't like, or to walk off the job. So that's kind of the dramatic piece here. And what this does is it just drives, at least with strikes, it drives the parties back to the table. Contract imposition is, I mean, you're stuck with the contract unless they decide to re-enter negotiations, which is why what you'll sometimes see is what's happened in the past with these teachers' strikes is the district imposes a contract and the teachers say, now we have to walk off the job. So that's not to say that strikes only follow contract imposition, but that's happened sometimes because they feel like the only way we're going to get a contract we're okay with is if we walk off the job. But at that point, both sides have literally lost everything because now school is closed. Your parents are livid. Your voters are livid, and you've got to find a way to get to common ground and get back to work. And so that really is kind of your last resort.
One of the ways that it was phrased by an old, just somebody who was discussing, at one point we were discussing getting rid of the right to strike, and they described it as the abyss, the moments when the threats have been made. It's like, are you willing to jump into a hole and not know where you're going to land? And that's really one of the things that pull people back to the edge. And we haven't really experienced all that many strikes over time, but when they've happened, there are still school districts that remember 30 years ago how bad the strike was.
You know, Yeah, and it's worth saying too, this isn't like it's usually not a surprise. There's usually an announcement that if we don't reach agreement by this time, we voted to authorize a strike. You know, so like we're on a deadline here. And if you don't reach agreement by then, each day the pressure builds for the parties to come to an agreement. So they are prohibited by statute for state employees. And that's pretty normal there. You don't want state government to shut down. So this is not an uncommon provision. It's really worth noting that, yes, a little fun with the clip art.
Gotta have some fun.
So it's worth noting that this is Vermont's system. This is not by any means, there is no one normal system around the country. When we did the possibility of banning teachers' strikes, we did a look at all the other states, what they do for teachers. Some states only have mediation before contract imposition. Some states ban strikes. Some states allow them. Some states go straight to fact finding or mediation. Some go straight to binding arbitration. None of the other. It's all over the place. The bottom line is that you set the ground rules here in the State House for how public employees around the state bargain their contracts. The push in the past few years has been to start standardizing these acts because, as you can see, they're all over the place. So what we've seen in past years is when it's adopted for one, it's adopted for all four. Whether we end up like some states where they just have a Public Employees Collective Bargaining Act, one act for the whole state, a miracle. That remains to be seen, but right now we're pretty far away from that, and it would take a lot of legislating to get there. But that's where the recent years have been moving towards, is sort of having more standard terms so that you know, like, what comes next in the process. It's 416, sorry. Okay. Appreciate you guys bearing with me. Good questions, and I'm sure you have plenty more, so feel free to just grab me when they come up.
Well, throughout the process, certainly.
Yes.
Thank you.
No, thank you, everybody.